My name is Veronica Lopez. I'm a business counselor manager here at Pace Business. I'll be your host and facilitator for today's webinar provided by uh, Tzedek, Small Business Essentials, Small Business Entity Choice Basics. This is a four-part series, and this is part number 3. Thank you all for being with us on time. So as I was mentioning, today's topic will be presented by Tzedek staff. So Marco R. Castaños, staff attorney with Small Business Development Program at Tzedek Legal Services. Before we get started with our main presentation, I'm just going to do a brief housekeeping. Okay. So everyone, of course, in listening mode. If you have any questions, you want to raise your hand to be unmuted, let us know. But for the main presentation, everyone will be muted. Feel free to enter any questions in the chat box. If you have any questions, we will be monitoring today's questions in the chat box throughout today's presentation. There will be a Q&A session at the end of today's presentation. We allocated about 10 to 15 minutes, but just depending on the presentation. Today's webinar is being recorded. You can visit our e-library. All of today's participants will receive a copy of today's webinar presentation, including the slides. We kindly encourage you to complete our survey at the end of the webinar. So we want to be able to have good feedback about today's presentation, but also to influence the programming for future webinar topics. So about PACE. So PACE is a nonprofit organization based in the Los Angeles area that provides economic justice by providing solutions to the problems of poverty, economic inequality in minority, ethnic, and immigrant communities. And our core programs consist of workforce development, early childhood education, energy environmental services, affordable housing, and of course, business development. So some of the services we offer is one-on-one consultation, various topics, anything from a needs assessment onto marketing to business plan review, legal considerations, but of course we refer to our legal partners as well. And then site location, lease negotiation. This is just to name a few. We have an entrepreneurial training program. It's a 10-part series. We offer it about twice a year, if not more. It's a comprehensive, people call it like a mini MBA to learn how to start a business. Although we also have existing or operating in business also attend the course. And of course, we have online courses and in-person courses similar to today's webinar. And then and in addition, we also have small business financing in-house through our PACE Finance Corporation. We offer loans from $500 to $350,000. We do pre-qualifications and we review lending requirements. We also help you find financing with other CDFIs that are our partners. We offer SBA loans, alternative financial services. We offer a credit review and then other lending or helping you prepare, get loan ready. And then lastly, through our WorkSource program, we offer employee hiring and workforce development. So if you're in the process of hiring employees through the WorkSource Center, there is an incentive program that helps cover 6 months of the employee's salary, so half of the salary to help that employee get trained. You could let me know if you're interested in that program. Okay, here are some of our upcoming webinars. Like I was mentioning, today's webinar is part of a 4-part series, so I'm glad for those who have been able to join us for the 3 parts. But please, come back for June 17, which is the last part on contracts for small businesses. And then this upcoming Thursday, we have digital marketing for women owned businesses, and that's also that one is very extensive. I think that's an 8-part series. You can scan the QR there in front of you, but we'll also send that information with the follow-up email to today's presentation. And so with that, please give a warm welcome to today's presenter. So Marco R. Castaños, staff attorney, small business development program at Tzedek Legal Services. So Marco is a staff attorney at Tzedek Legal Services, and through his work at SBD, Marco delivers pro bono legal services and know your rights presentations to small business owners and community members in Los Angeles County. So with that, we're going to transition to Marco's slides and welcome Marco to PACE and for providing this presentation to our small business community.
Thank you so much, Veronica. Let me get my window shared. Is that coming through okay?
Yes, it's visible now. Yes.
Perfect. Thank you so much. Um, and as you mentioned, this is part of um, a series, and we appreciate the opportunity to work together and collaborate on these types of presentations, and provide this information to our community members, small business owners, entrepreneurs. This is the type of work that we do here at Tzedek, which I'll have the opportunity to discuss in more detail just shortly. So just following along, as you mentioned, my name is Marco Castaño. I'm a staff attorney here at Tzedek Legal Services in our Small Business Development Program. Today we'll be talking about small business choice of entity. This is a question that comes up very often with business owners, with entrepreneurs at the startup stage, or several years down the line, where they are considering what is the most effective, the most efficient vehicle for their business. This is going to be an opportunity to talk about what these different entities are, to dispel any information or misinformation that you might have had gathered from, friends, family, social media about your business. And I'm really here to make this world of law as straightforward and understandable as possible for you all as business owners and community members. As the presentation goes on, I invite you to put questions in the chat. That doesn't mean I'll answer them right away, but that's a way for us to, kind of bookmark them, know what the questions were, and allow me and Veronica to reference them later on once we get to the Q&A portion, okay? So first off, starting with who we are, here at Tzedek, we are a nonprofit legal services agency. We've been in LA County for 51 years. And traditionally, we're recognized, for the work that we've done across some of our legacy practice areas, eviction defense, workers' rights protections, supporting the needs of Holocaust survivors, certain aspects of immigration law. We're able to do this work regardless of an individual's race, religion, ethnicity, or immigration status. And I'm part of our small business program. Our small business program is designed to help low to moderate income entrepreneurs and small businesses. And we only provide transactional services. I'll talk in a moment about what that means, but our transactional business matters. We approach these services through community presentations and workshops, such as this one, through our small business legal academies, which are presentations like this that also include the opportunity for a half hour to 1 hour consult for free with an attorney on your legal questions. We also generate guides and other free resources that include recordings of presentations such as this one. And ultimately, I'm an attorney. We have other attorneys on the program, and we provide direct client representation. When I talk about transactional business matters, these can include these topics, right? Business structure and entity formation, review and negotiation of contracts, review and negotiation of commercial leases, review of employment law compliance and generating, internal paperwork if you are an employer or hiring entity. We're still doing work related to COVID relief and the remaining consequences and ramifications of those, trying to negotiate away any outstanding debt or compliance with any type of loan vehicles that were made available during the pandemic. We can also provide services around intellectual property protection, internet privacy, business insurance, and bankruptcy. people, get really excited about our work related to direct representation. So with that in mind, since we only provide free representation, free direct services, this requires going through a series of questions to confirm that you and your business are eligible for our services if you're interested in pursuing them through us. Now, these questions depend on our funders and our donors to make sure that we are in compliance with their requirements. So we would have a conversation around the household's income, around the business's profits and sales, and our services are restricted to for-profit businesses only and in LA County only. And as I mentioned, we don't offer litigation services. We can provide services across languages and abilities using our internal staff and our language line. So accommodations will be made to our applicants and clients. I'm going to leave this slide up for just a moment. And Veronica, if you could please help me with including these links in the chat. They are links to our online resources, to my direct email address if you'd like to get in touch, and to our application for assistance if you are interested in direct services. You would fill out that preliminary application, and we would be able to follow up with you to schedule a conversation. Thank you, Veronica. Moving on, let me slow myself down because I'm already out of breath. But before we get started, I need to read this out loud. This is our disclaimer. So, the following information is intended to assist in spotting legal issues relevant to small businesses in the state of California. There are many factors to be considered in determining which actions and decisions would be most appropriate to any specific situation. This presentation only discusses some of the more important factors, and it is not intended to substitute for legal advice. You should decide which course of action is best after discussing it thoroughly with an attorney. This is to say, I am an attorney, but I am not your attorney. Anything I'm sharing here is legal information only and should not be construed as legal advice. When we get to the question and answer portion, if you have questions about your specific situation, I won't be able to discuss that. What I can do is share information in general terms related to the general situation that you or a similarly situated business owner might find themselves in. So these are entity choice basics. This is the conversation that gets started around people seeing announcements regarding their LLCs or forming an S corp or operating as a sole proprietor. Or a sole proprietor is seeking outside investment and wants to know what the best thing to do is. Or a entrepreneur hears that they have a great idea, but somebody told them that they shouldn't start until they have an LLC or a corporation. Or the most common one is somebody hears at the outset, oh, you need to form an S corp because that's the only way you're going to turn a profit. My intention in having this conversation is to inform you all as to what's most appropriate depending on your stage, depending on your needs, depending on your industry and your clients. There's no one size fits all answer, and there's no way to say for sure your business is going to do best only if it's an LLC or only if it's a corporation or only if it's a sole proprietor or only if it's a general partnership or only if it's a limited partnership. That's not how businesses operate, and that's not the legal answer to many of these questions. So what I hope to do is help inform you so that you can identify the questions, identify the intersections of an attorney so that you know when it's going to become most efficient, most relevant, and most cost effective to reach out to and speak with an attorney. And that's because, as I mentioned, first of all, we don't have too many attorneys in our program. We definitely can't handle all of the need in LA County. Second, many of you whom we would like to support may end up not being eligible for services, so we can't help you directly. So what I want you to do is know, if you can't get in touch with a free attorney, how to make your time with a attorney for fees the most efficient use of your time and their time as possible. So generally, there are common business entities that intersect with business ownership in California. Those can be sole proprietorships, general partnerships, limited partnerships, limited liability companies or LLCs, corporations, and worker-owned cooperatives. Each of these involves a wealth of information and a deeper conversation on how they operate. And many of these can blur the lines between one another. So this is going to be an opportunity to identify the basics of each one and consider which one is going to be most relevant for the stage where you are in your business. These end up being limited or refined depending on your industry, because there are certain industries where that require a specific type of business entity, and we'll get into that in a bit. But starting off, we have sole proprietors. And if we were to envision this in the lifeline of an entrepreneur, of a startup, this is where we would get started. A sole proprietor is an individual doing business. Legally, they're doing business as themselves. That's why it's the most straightforward and simple business structure to manage. I specify that it's doing business as themselves because there's no legal distinction between the business and its owner. That means any liability assumed by the business is also assumed by the owner. And that means all of the owner's personal assets are also the business's assets. Any property that belongs to the owner also belongs to the business, and vice versa. This is because it's the most simple and straightforward to maintain. There's no filing documents. There's no incorporation documents. There's no annual fees that need to be filed with the state or the federal government. And when it comes to taxation, it's the most straightforward because this is just your personal income and your individual losses. A sole proprietor, by definition, only has one owner. And as I mentioned, it creates no legal distinction between the owner and its business operations. That means that the owner's liability is very high. A common route for a sole proprietorship is to create a DBA or an FBN. They're the same thing. It's a fictitious business name or a doing business as. This is a document that you file at the county level that essentially says, hey, I'm operating this business as myself, but I want to use a different name for it. Although you file that document, that's not a creation document, and it doesn't create any legal protections. So the consideration here is it's simple, it's straightforward, basic, has low costs, but creates a high degree of liability for the owner. So a consideration you should take into account as an entrepreneur or business owner is, does my work create substantial liability? Does my work substantially expose me to potential plaintiffs? Am I doing something that's very dangerous? Or am I handling products that are very sensitive, right? If you are in the business of transporting unique pieces of art, well, every time you receive one of those and transport it and convey it to the next person, that's pretty risky. So think to yourself whether you're willing to assume that risk individually. In line with the sole proprietorship is a general partnership. Imagine that sole proprietor that we picked up in the first slide or in the previous slide finds somebody else who does the same work and they want to do the work together. But they're not filing any type of incorporation or formation document. They're just together doing the work. They're sharing the profits. They're sharing the work. They have some decision-making procedures as far as how to hold themselves out to clients and customers. But at the end of the day, it's just them two operating as general partners. Even if there's no written agreement, they're still operating as a general partnership. There's no formal filing or registration requirements at the state level. And that means still each individual partner is personally liable for the business's operations. And their personal assets are exposed through the business's operations. By definition, it needs to be two or more people, but the conceptual framework, the baseline, is similar to that of the sole proprietorship. There's no legal distinction between the owner and the owners and the business. Here, you're going to want to consider how you want income and expenses to be divided between owners, and that can create some relatively complex tax considerations. But this is still a step below some of the formal business entities. So tax considerations here can be tricky, although useful. But again, this is a highly risky endeavor that really becomes your decision whether you still want to be personally exposed or personally liable for the work that your business does. Personally exposed or personally liable, again, means your personal assets become exposed to your business's customers or any other injured party through your business's operations. Now, on our lifeline, right, of the business that we've been working with since the first slide, let's say these two business owners find somebody else who wants to be an investor. This investor doesn't want to be responsible for the day-to-day operations, but they do want to be able to collect a profit on their investment. We've reached the realm of limited partnerships, LPs. A limited partnership is a hybrid type that sits on the intersection between our entities that offer no liability protection and our entities that offer significant or substantial liability protection for its owners. So a limited partnership is created at the state level, does rely on a filing at the state level, and it's made up of these owners, right? So remember, our general partnership had two owners, had two general partners. Let's stick with them two. So we have one or more general partners that are responsible for the day-to-day operations of the business. These general partners remain individually liable for the business's operations. They are offered no liability protection through the structure of the business, and that means their personal assets remain exposed through the business's operations. However, remember we had that silent investor, this silent partner that just wanted to invest some sum of money, but doesn't want to be involved in the operations. Well, they're a limited partner. The limited partner doesn't take part in the day-to-day operations and in fact cannot be involved in the day-to-day operations. The limited partner submits some sum of money, can participate in like broad organizational meetings related to profits, losses, and elections of officers, but they are not responsible for the day-to-day. They cannot assign tasks. They cannot delegate assignments. They don't supervise or oversee employees of the company. They are there to invest and collect on their investment. As the limited partner, as long as they follow through on these requirements, well, then they are afforded liability protection. That means their personal assets are protected and are not fair game in the event of a lawsuit against the business, right? The general partner, their personal assets are at risk in the event of a lawsuit. But a limited partner, as long as they're complying with all of these steps, their personal assets are not at risk in the event of a lawsuit. In fact, a general partner is only exposed to the extent of their investment, to the extent of however much money or property they've conveyed to the business. That's really what ends up exposed. This can be relatively straightforward to create. However, as I mentioned, it does require a filing with the Secretary of State. And since it is created by a filing, it is also subject to California's annual franchise tax. That's the $800 minimum that certain entities that we'll get into in a moment are required to pay. So we've reached this part of the conversation, and it's a common one, right? We really want to be here because this is where questions come up. Limited liability companies. What is an LLC and when might it be relevant to me? So an LLC is a limited liability company. It's a business entity type created by statute at the state level in California. A limited liability company allows you to operate your business in a straightforward manner without too much complication, but still obtaining and receiving that protection of your personal assets from the business's operations, right? An LLC can have one or more owners. It's created by a filing with the California Secretary of State. It also requires biannual renewals at the Secretary of State. And it requires the minimum annual franchise tax of $800 to the California Franchise Tax Board. This can be relatively complex in the sense that a diligent LLC will have an operating agreement that determines the roles and responsibilities of its various officers, how decisions are made between owners, and distributions between and among owners. That means that how the owners pay themselves from the business's earnings. The liability protection comes at a cost, right? If you want to enjoy the liability protection, you need to be ready for the filing fee, which is $70 one time and $20 every 2 years, starting with the first year, and then those $800 a year. But the protections aren't automatic. In order for you as a business owner to reap and retain those protections, you need to follow through on the requirements. One of them is capitalizing your LLC. It isn't enough just to create your LLC and continue doing business with your personal bank account. Part of forming an LLC is also obtaining a separate tax ID number for your company, called an employer ID number or EIN, freely available on the IRS website. You use that tax ID number to create a separate bank account. You can take your personal assets, your startup funds, you convey them to your LLC. They no longer belong to you, they belong to the company, and that's what the company is going to rely on for its operations. That means that the business's bank account is going to then have a balance. If your business's bank account doesn't have a balance, but it is in operation, and you find yourself embroiled in a lawsuit, well, then any court is going to ask, where's the money coming from? And where's the money going? If it's just coming from your personal account and just going back into your personal account, well, then you're not respecting the division, the distinction between the LLC and its owners. And if you're not respecting that division or distinction, well, then you're not going to be able to reap and obtain and enjoy those liability protections. I hope that makes sense. Depending on how many members of the LLC, the operating agreement can be more or less complicated. And depending on the profitability of the LLC, tax considerations may become more or less complicated. Before moving on, what I like to say here is if you are considering forming a limited liability company for your business, there are a few things to take into account. What are your personal assets? Do you have substantial personal assets that you need to protect? If you do, well, then this might make sense for you. What industry are you operating in? Are you operating in an industry that's very risky? Like we talked about at the beginning. Are you an art dealer, or are you conveying and transporting priceless, invaluable pieces of art that are unique? Well, that's very risky, and you want to be able to protect your personal assets, depending on if they're large or small. And if you're doing risky work, then it might make sense to create a separate business entity. Additionally, what types of commercial agreements are you entering into? And in these commercial agreements or contracts, who do you want to be responsible? Do you want to be you, the business owner, the individual? If you're the one signing the contract, well, then you are personally liable for its terms. Even if the business goes under, even if the business is no longer in operation, you signed that agreement as a person, you as a person are responsible. However, if the LLC signed the agreement as a separate entity, well, then that separate entity is responsible for the terms, and that can be a viable exit strategy for the business owners. And finally, in line with what type of industry you're in, do your customers expect to be dealing with an LLC or a corporation? Do your customers expect that degree of formality or professionalism as a way for you to indicate or signal or convey, as I mentioned, a level of sophistication? So again, no one size fits all answer, something to consider. Next, we have corporations, and I'm going to tackle these next two slides together, S corporations and C corporations, because there is a lot of misinformation here. A corporation for us is a California stock corporation. It comes from generations of common law in this country and other countries that gave us our foundational laws. And it's essentially the original corporate body. It's the way for multiple owners called shareholders to come together and carry out a project on their own. For our sake, it's a business. It's a way for multiple owners to come together, pool resources, create a business, operate in a formal sense by assigning to each other roles and responsibilities as officers, to operate as a board of directors that then instructs its officers how to operate and ultimately create profits for their shareholders, right? Corporation has three levels of ownership and management. There's shareholders that own the company by its shares. The shareholders elect directors to the board of directors. The board of directors are responsible for generally overseeing the company, but they delegate those roles to then the officers. And the officers carry out the day-to-day business. That's the CEO, the president, the vice president, the secretary, the chief financial officer or treasurer. For our sake, for small, closely held corporations, that can be the same person, that can be the same two people, that can be the same three people. The same person holds all the shares and is the only one sitting on the board and is also the president, CEO, and treasurer, right? That exists. That's fine. But they still need to abide by those corporate formalities and understand these tiered levels of ownership and management. That's responsible. I mean, that's important because corporations are still required to abide by federal and state securities laws. If a federal or state agency conducts an audit, they're going to say, did you have your annual meeting? Prior to your annual meeting, did you did you distribute the required notice of the annual meeting to all the shareholders? And that's the type of information that needs to be stored in your corporate documents, right? So there are certain corporate formalities that you need to abide by in order to maintain a corporation in good standing, to maintain a California style corporation in good standing. So that's why we consider these to be relatively complex. On top of that, the costs can get high. They are comparable to an LLC's costs, although an LLC is slightly less financially burdensome. But you're going to have the filing fee for the articles, anywhere between $70 and $100. Your statement of information, which is a filing you need to renew every year. That's $20 to $25. And the franchise tax, $800 a year, every year, starting with the first year. Now, let's move on to the federal considerations for the California Stock Corporation. And here's where we tackle both of these slides at the same time, C Corps and S Corps. California Stock Corporation is taxed by default federally as a C Corp, has C Corp status. C Corps are taxed on their business income and they're taxed on their distributions. That's what's called double taxation. The money that comes into the business is taxed, and the money that leaves the business to its shareholders or to its employees is also taxed. That can be understandably burdensome. So the federal government has created the S Corp designation for small, closely held corporations, but also LLCs, right? If you'd like, your LLC and or your California Stock Corporation can obtain S Corp status. This doesn't exist at the state level. At the state level, there is a minimum tax, $800, no matter what. If your business income is in excess of $200,000, then your state level tax is $800 plus a certain percentage of profits above 200,000. At the federal level, however, you're taxed based on your income. Um, and for small corporations and certain LLCs that elect S Corp status, you can obtain S Corp status and obtain its benefit. But we're going to talk about what those benefits are and what the requirements are to reap those benefits. In order to apply for and be eligible for S Corp status, your corporation cannot have more than 100 shareholders, and none of its shareholders can be other entities, including corporations, LLCs, or partnerships, or trusts, and none of them can be foreign citizens. An S corporation can only issue one type of stock. That means that you can't issue tiered levels of stock that afford different benefits depending on what type of stocks you own, depending on what types of shares you own. The advantage here is that they are not subject to double taxation. They are subject only to single taxation. For a S corp in good standing, business income is tax-free. Distribution are taxed at, employment tax, right? So the money that comes in is tax-free, and the money that flows out is taxed at the self-employment rate or at the rate for employees. So you could feasibly hire yourself as an employee of the business. So when you take your distribution, the deductions are already there as, what a regular W-2 employee would be taxed at. You might think to yourself, oh, that's awesome. That means that I can keep a ton of money in my business and all that money is tax-free. That's pure profit for my business as long as I take a low distribution. And then my business gets to use and enjoy this income as for its own development, for its own growth. And that's tax-free money. Surprise, the IRS already thought of this. So the last requirement for S Corp status is that the employee or employees are paying themselves what's called a reasonable salary for their industry. IRS is going to check. Oh, this is an industry where people usually earn $45,000 a year. Then they're going to expect you to pay yourself $45,000 a year. If your business only earned $60,000, let's say, and you don't pay yourself $45,000, you pay yourself only $20,000, and the remaining balance stays in the business's bank account, tax-free, well, then you're risking your S Corp status. They're going to want to see that money really, really flow from the business to its owners, and that distribution to its owners is taxed appropriately. So things to consider. This S Corp status really only starts to come into play if you are operating at a level where you can pay yourself a reasonable salary based on your industry, okay? So it's not something to consider doing at the startup phase when you barely start operations, but rather as part of your business plan for, okay, here's my business plan. Once I start seeing this much money flowing in gross receipts, well, maybe it's time to start considering the tax implications, and it's time for me to start considering when might be the right time for me to select a more advantageous tax registration status. And again, S Corp status is available to corporations and to LLCs. On these next few slides, we just have generally a table that shows how these different entities can be more or less complicated and what are some of the requirements for each. You can obtain a fictitious business name in any of them, but it's mostly relevant for sole proprietors if you don't want to operate just as your name. Only limited liability companies and corporations require these founding documents. A limited liability company should also have an operating agreement, whereas the corporation should have bylaws that lays out the relationship between shareholders, directors, and officers, the rules and how the business operates and what are the relationships between all these actors. Um, you want to consider, especially for those last couple, using the employer ID number so that you're really showing that it's a different entity that collects money differently and is taxed differently. And ultimately, we start talking about things like business licenses, tax registration certificates, and licenses based on industry. So we're getting close to time. So I want to leave you on this slide, which is CalGold. Um, it's located at gobiz.ca.gov. And this is a really, really neat website where you can search by your city or county and your industry. And it's going to tell you for your industry in your location, what are the licenses that you're required to obtain, right? Because one thing is for your business to operate as a separate entity, but it's another thing for your separate entity to obtain, to then obtain and keep the proper licenses and certifications based on your location or industry. With that, here's the same slide that we saw earlier, and I make myself available for questions.
Okay. Thank you, Marco. I'm not sure if you can hear me, but we have
I can
one
hear you.
question. Okay, good. We have one question. So, does or should having employees factor into an entity choice at all? And does it matter if employees are part-time or full-time?
Great question. And it leads to many other questions regarding your employment practices and classification status. And we can have a separate conversation about that. Generally, right, there's no hard and fast rule that says only such and such entity can have employees. And there's no hard and fast rule that says if your employees are working this number of hours, then you are required to keep this entity. What I can say generally is gonna, refer back to what I mentioned earlier as far as risk, right? In the state of California, employment law is a very well thought out, very robust legal sphere. There's a lot of laws, there's a lot of compliance issues related to employees, both full-time and part-time, but obviously full-time employees work more hours, so they're gonna lend themselves toward more exposure for your company. So you want to think about what does it mean to protect your business from risk, from liability, not just from current employees or former employees, but also aggrieved customers, clients, providers, commercial clients, people that you're signing contracts or agreements with, right? Employment is a contractual relationship. It's a contractual relationship that's governed under state law. So are you as an individual ready to comply with every level of state law? I'm not going to sit here and tell you that it's easier to avoid state law if you're an LLC versus a corporation. If you're an employer, you should be diligently following all employment law practices. And if you are in following all employment law practices to a T and you have your liability at zero, then it doesn't matter who's hiring because you're not exposed. But we know that that's not the world we live in. And you can try your best and still be liable. And you can do everything right and still have missed something, or any party is still able to bring a claim against you, even if you've done everything right, right? Or even if you thought you've done everything right. So it becomes a question of who do you want assuming that exposure? And then under that level of sophistication, right? If you're sophisticated enough to be hiring people and paying them minimum wage and abiding by California minimum wage and hour laws, that reflects a degree of sophistication, income and expenses, profit and losses for your business. So maybe then it does become time for you to consider a formal separate entity and a more favorable tax status that would help you on your taxes, on your double versus single taxation when it comes to having employees. So it's like a chicken and egg question, right? If you're sophisticated enough to have employees, maybe consider a more complex entity type. Also, um, if you are assuming the risk of hiring employees, maybe also consider an entity type that has robust liability protections as it relates to risk. A conversation that's missing here, because it's part of a different presentation, but still relevant, is the conversation of business insurance. And business insurance is a very effective and fundamental way of protecting your business, whether you're a sole proprietor, whether you're a general partnership, or even if you're an LLC or corporation, right? An LLC or corporation, let me put it this way. A sole proprietor with sufficient insurance can be more protected than an LLC without any insurance. Okay? So even if you're operating as an LLC or corporation, definitely take some steps into exploring what insurance policies are out there for you as far as business insurance, as far as commercial liability insurance, because that's a step that's also relevant if you're a sole proprietor.
Okay. I guess in a related question, are there specific industries where one type of entity type is is more advantageous or provides better liability because of the industry that it's in?
I can't answer that, but what I do want to answer
Okay.
is because it goes the other way, right? It doesn't go in that direction, it goes in the other direction.
Okay.
There are certain industries where that don't allow that liability protection. There are certain industries that expect the business owners to hold themselves personally liable or more closely liable because of the very nature. So I'm talking about professional industries, professional services, um, licensed industries. So accountants, attorneys, medical professionals,
Financial
they're
advisors?
required to form what are called um, APCs. If they want to create a separate corporate entities, if they want to create a separate corporate entity, they can't just go the regular corporation or LLC route. If they do, they need to create what are called APCs, a professional corporation. And a professional corporation comes with its own level of requirements in licensing and insurance to make sure that these owners, since they're licensed professionals, aren't just able to kind of get away scot-free in the event of malpractice.
Mm.
But we start thinking about other industries, right? I highlighted one, right? And these are just suggestions. I can't give you a hard and fast rule, but like if you're an art dealer or if you're transporting art, um, maybe a separate entity is right for you because you're dealing with a lot of risk. If you're in construction, right? If you're a contractor, you're dealing with very valuable contracts and you're dealing in real property where somebody can get hurt or there can be some kind of accident and the project sustains huge losses. You don't want to be personally liable for that.
Hmm.
On the other hand, If your business is something very straightforward that has very low risk, let's say you are a consultant, but your work comes with a disclaimer that says everything your clients do is at their own risk, and you're not responsible for any losses or damages that they endure based on following your advice, right? That your advice is for informational purposes only and is issued at your own risk. And you have acknowledgments and waivers and consent forms as part of your client process, client onboarding process. Well, then maybe operating as a sole proprietor makes sense for you because you don't have to pay those $800 a year and you're still protected, and it's not an industry that assumes a ton of risk.
Okay.
I see we got another question.
We do. Can you change entity type at any time? Is there ever a wrong time? So we actually had a related question. So as a business grows and it evolves, is it common, very similar to this question, for a business to start changing entity type as it grows? Mhm.
Absolutely, right? Absolutely. And that's what we expect, right? Who you are at the beginning isn't who you are 2 years down the line, 3 years down the line, 5 years down the line, 10 years down the line, right? And that's fine, and completely normal. Um, we have to think about what a business is, right? The business isn't the entity. The business is your intellectual property, your relationships, your contracts, things that you're able to leverage into profit, right? So it's perfectly feasible for you to operate as a sole proprietor, develop these relationships, have a certain stable stream of income, and then decide for yourself, I want something formal. You file your LLC formation organizing paperwork, and for the state of California, they're saying like, "Oh, you were just created." But you know for yourself that you've already been in operation for 3 years. All you wanted was to create a formal entity type. So for the state of California, you might be 1 year old, but you know that your business is 3 years old, and that's fine. So that's not really changing entity type as much as creating a new entity, because as the sole proprietor doesn't really exist. The sole proprietorship is just you. So
Mhm.
you're not changing from sole proprietorship to LLC. You're just taking your sole proprietorship and creating an LLC and migrating your business there. So for the state of California, you didn't change entity type, you created a new entity. So then to answer this question, if you wanted to change from LLC to corporation, yeah, you can do that at any time. You can file what's called a conversion. Straightforward with the state of California, Secretary of State. You say, I want to convert my LLC to a corporation, or vice versa. That's totally fine. Gets tricky when we want to say we want to convert an LLC to a sole proprietor, right? Because we know that one is at this level of complexity and one is at this level of complexity, right? The LLC is more complex than the sole proprietorship. Even if you think you're changing your LLC to a sole proprietor, that's not what the state of California sees. The state of California sees you want to dissolve your LLC and you want to continue operating as a sole proprietor. But that's not a conversion, that's a dissolution. Um, so that's perfectly reasonable. That's totally fine. You can have created an LLC and then decided for yourself, it's not worth it. $800 a year isn't something I want to do right now. I think I can get by just operating as a sole proprietorship. You can't change, you need to dissolve. So then the question becomes, is there ever a wrong time to dissolve my LLC or corporation? Um, and I can't say that there's a wrong time, but I can say that there's a best time. The best time is within the first year of organizing. You want to say like, oh, I organized my LLC today, May 2025. and you're already realizing that, hey, maybe it's not the best idea. You want to dissolve it before April of next year, right? You want to dissolve it before the tax year ends, because you want to be able to make the argument to the state of California to say, hey, I did it, but I learned something else. I realized that I shouldn't have done it. I want to dissolve. I never took steps in operating. And the state of California is going to want you to have dissolved within the first year so that you don't pay those $800.
It's a good tip. Yeah. So we are at time. So thank you everyone. And hopefully we answered all your questions. And like Marco mentioned, he is available via email if you have any additional questions. And also, of course, I'll enter the application. I encourage you all to set up an individual appointment with one of the staff at Tzedek in case you would like more specific questions to any of your business entity formation questions. And then, of course, always, if we can give a round of applause, if that's possible, to Marco. Thank you for having us. It was a great presentation, very thorough and detailed. And I know that you barely touched the surface, that there's like so much complexity in all of this. And for all of you who have not yet started your business entity information, I really, really encourage you to reach out to Bitsadec team to schedule an appointment, especially in this matter because of the type of industry you're in, and then the type of liability that you may, or you're not really clear as to the type of liability you might. Be reflected for your business. And like Marco said, maybe in your industry, it's a combination of the entity and insurance. And that, of course, is out of scope for them, but it would be good to, a referral for an insurance agent or someone who can best fill in any gaps in the liability. So thank you all for joining us, and we will see you next time. Hopefully, any of you have been with us throughout the series. We'll come back in June and finish out the series. So, thank you again, everyone, and you have a great rest of your afternoon. Okay, bye. Thank you, everyone, for coming and joining us. Bye. Till next time. Bye.
Thank you all.